Hi, I'm Jane Dearwester with McIntyre Elder Law. I am a full-time litigation attorney with our firm, and one of the things I handle very often are will caveats or will contests, where a family member comes and says, my mom or dad or loved one changed their will 2 weeks before they passed away and left everything to their preacher, or left everything to the garbage man, or left everything to somebody outside the family. And so what I'm going to talk about quickly today is undue influence. Undue influence is one of the theories that we use in a will contest or will caveat case to set aside a will that was maybe procured by what we call undue influence. So in North Carolina, there are a couple factors that would make a strong case for undue influence. You have to have a testator, that's the person making the will, who is in a weakened mental and or physical condition. They have to be in this weakened condition to show that they are susceptible to somebody influencing them. If this person is a very strong and sound mind, you're not going to have a good case of undue influence. So you want to have someone suffering from cognitive decline or some kind of physical chronic condition that makes it difficult for them to go about their daily life. You want to see the person who may be benefiting from this change in their will has some kind of special confidential or fiduciary relationship with the person who's changing their will. This person who's exerting the undue influence also, you want to look at how active of a role do they have in this person changing their will. Did they make the appointment with the attorney and drive them there, and they were in the room the whole time and they never had any free time with the attorney? Is this person really driving the bus and not the person who's trying to make an update to their will? And is that person who is actively involved, do they become the sole beneficiary of the new will that is signed? Another thing to look at is if the person had previous wills, does this new will differ widely from what they had in place before? And does it give property outside the family, or does it divide property in extremely unequal shares? Now, all this said, when you're putting your will together, you don't have to split everything equally. You don't have to leave things to your family members. There is no rule that says you have to leave things to people that you're related to. But when you change things over time, and especially under these circumstances where you may have diminished capacity and there's someone close to you who is, again, directing you and kind of pushing you along to make these changes, and ultimately they are benefiting from it, that's the type of case of undue influence where the law provides an avenue for parties to the will or beneficiaries or heirs at law to challenge a will that comes on later in life that may not truly be what the testator, what the person making the will actually intended. It's really the intentions of someone else. So through discovery, through written discovery and depositions, we kind of flesh out what happened. We'll depose the drafting attorney who drafted the will and ask the drafting attorney all kinds of questions about who contacted you, who paid you, who was in the room, who did you talk to. So these types of things are how we handle will contests or will caveats regarding undue influence. If you have somebody in your life who you feel is being manipulated by another friend or family member, please give us a call, be proactive about that. There may be something we can do while the person is still living to put a proper will in place. You can give us a call here at McIntyre Elder Law, and just remember we have 3 offices in Charlotte, Shelby, and Hendersonville.